Republican Congressman Tony Gonzalez of Texas has just confirmed he plans to retire from Congress. I want to go straight back to CNN's Manu Raju on Capitol Hill. Manu?
Yeah, this has been a scandal that has engulfed this congressman for several weeks in the aftermath of revelations that he had an extramarital affair with his aide. That aide later died by suicide. Initially, Tony Gonzalez had denied having any sort of extramarital affair, but as the allegations were mounting, he admitted to that. Then he decided not to run for re-election, and he indicated repeatedly that he would not resign his seat from the House. But moments after the decision by Eric Swalwell, caught up in a separate sexual misconduct scandal, Gonzalez himself making the decision to resign following Eric Swalwell's decision to resign. Gonzalez himself saying he will step down from Congress, saying on X, saying there's a season for everything and God has a plan for us all. When Congress returns tomorrow, I will file my retirement from office. It has been my privilege to serve the great people of Texas.
What's happening, guys? Welcome back to Jack Mockler. 3 cabinet-level departures, Attorney General, Homeland Security, Labor, happened in a short window. But viral claims that they've flipped to cooperate with prosecutors against Trump are fictional, not documented reality. What is real? The departures weaken perceived stability, invite questions about why insiders are leaving, and fit a pattern of historically high turnover in this administration. The fictional flip narrative is built on a real foundation, a foundation of genuine instability, genuine legal pressure, and a genuine historical record of Trump allies from the first term eventually cooperating with investigators.
Now, the decision by both Gonzalez and Swalwell has a couple of key ramifications, one of which is that they both can avoid a House ethics probe. Both men were facing an investigation, but now that members are no longer serving in the House, that committee, the Ethics Committee, no longer has jurisdiction over those members, and expect that those investigations essentially to go away. Also, both men were facing expulsion votes in the United States House. That potentially could have succeeded. It would have required 2/3 majority in the United States House to go ahead, and both of those members clearly looking to avoid that possibility here. But Gonzalez had decided to stay on as a result of perhaps the Republican leadership not calling on him to step aside, because Anderson, as you know, this is the narrowest of majorities in the United States House. Had Eric Swalwell still been a member of Congress and Gonzalez had resigned, Johnson would have zero margin for error. He could not afford a single defection in the United States House. But now that Eric Swalwell has resigned,
understanding both the fictional amplification and the real foundation is essential for evaluating what these 3 departures actually mean. So let me walk you through what we actually know about each of these 3 departures, the specific circumstances that surrounded them, because the specific circumstances of how officials leave an administration are the most relevant information for evaluating whether any cooperation with investigators is plausible or documented. The Attorney General resigned under pressure amid fierce criticism over her handling of the Epstein files.
Gonzalez plans to do the same. That means that Johnson can still afford to lose 1 Republican vote on a party line vote, which shows you how every seat is so critical in the narrowly divided Republican House.
Manu Raju, thanks very much. Were you surprised by this?
Honestly, with great power comes great responsibility, right? And so if you are in a position of power and you utilize that power in a way that sexual assault becomes a thing, it's just not appropriate. And, a serious investigation needs to take place in something like this. It needs to be thoroughly investigated, and I think that's what's going to exactly happen.
Sure, Michael. Tony Gonzalez, this has been going on for a while. It seems like Swalwell announcing is what made it, I don't know if it's made it possible for him, sort of from a political standpoint, because it wouldn't necessarily change the balance of power. He seemed to invoke God in his statement, but why now?
Yeah, the irony of invoking God after the woman that he was alleged to have had an inappropriate relationship with killed herself, a lady who was married, family, friends who cared deeply about her. I mean, this is pretty despicable. What's unfortunate about all of this to me, though, Anderson, let's just put the politics to the side.
We have covered this extensively in previous videos. The accountability failures were significant. Document release failures. Heavily redacted materials that should have been made public. a Republican congressman catching a co-conspirator's name hidden in redactions until he confronted the Department of Justice and it was unredacted within minutes. Accusations of misleading statements from members of both political parties. That is why she left, not because of any reported decision to cooperate with investigators into Trump. The Secretary of Homeland Security left for a private sector security role. The White House framed this departure as a reassignment, but news outlets treated it as a cabinet exit.
There's been over $17 million, or roughly $17 million, in payouts from members of Congress on both sides to keep quiet sexual assault. I believe Nancy Mace out of South Carolina had a bill, I think a month ago, that she attempted to get passed in Congress to reveal who are these members who have paid out after being alleged to have had inappropriate relations with their staff members. And Congress voted against disclosing who those members are and were, if some of them are now out of Congress. Just imagine that, taxpayer dollars paying to cover up this type of atrocious behavior by the representatives that we elect to serve our interest. It just doesn't make any sense to me. It falls below despicable. And I'm saying this as a conservative. I don't look at this as a right or a left thing. I have a 1-year-old daughter now. And to me, when I think about powerful men doing things against women who are subordinate to them, who can't really defend themselves, who may be afraid to speak up because they don't want to lose their jobs, and then our elected officials on both sides had an opportunity to say, you know what, we're not going to stand for this anymore. We're going to disclose the names. We're no longer going to pay out to protect powerful people. And they decided to bury it. Just imagine that, Anderson. In what universe would a moral society say that that is acceptable, that is okay?
It's bizarre to me, Chris. I mean, the behavior, obviously, if the allegations are true against Representative Swalwell, there are legal ramifications for the Republican congressman.
No dramatic scandal attached to this departure. No allegations of misconduct. Just an official leaving for what appears to be a better opportunity in the private sector. The Secretary of Labor resigned while under an Inspector General investigation. That is the most legally significant of the 3 departures in terms of the active oversight process that accompanied it. An Inspector General investigation was ongoing at the time of her departure. That means there was a formal inquiry into potential misconduct within her department happening while she was still in office. She chose to leave rather than continue serving under that cloud. But none of these documented departure circumstances include any verified report of cooperation with federal prosecutors. The Attorney General's departure was driven by accountability failures on Epstein files, not by any reported decision to cooperate with investigators. The Homeland Security Secretary's departure was reported as a private sector move, and the Labor Secretary's departure was associated with an Inspector General investigation of her own conduct, which is a very different thing from cooperating with prosecutors about Trump's conduct. Now let me talk about the specific historical context of first-term departures and cooperation, because this is where the fictional flip narrative gets its fuel. The real record of Trump allies eventually cooperating with investigators is the historical foundation on which the fictional story is built. Michael Cohen flipped. He went from saying he would take a bullet for Trump to testifying against him in a congressional hearing and in the hush money trial that produced 34 felony convictions. Paul Manafort reached a cooperation agreement before ultimately being found to have violated it. Rick Gates cooperated with the Mueller investigation. Michael Flynn cooperated after initially pleading guilty. The first-term pattern of Trump allies at various levels of the organization, not necessarily at the cabinet level but certainly within his inner circle, eventually cooperating with investigators is a real documented historical pattern. The fictional flip narrative is extrapolating from that pattern to these 3 current cabinet departures. It is imagining that the same dynamic that produced first-term cooperation from Cohen and others will produce second-term cooperation from these 3 officials. That extrapolation is the specific thing the fictional content is doing, and it is not supported by any documented evidence about these 3 specific officials. But it is not entirely disconnected from a real historical pattern either. Understanding both the real pattern and the absence of documentation connecting these specific departures to any cooperation agreement is the most accurate available assessment of what the flip claim actually represents. Michael Cohen went from loyal fixer to cooperating witness. That really happened. The pattern of Trump allies flipping is real and historically documented. But the application of that pattern to these three specific cabinet departures without any documented evidence of cooperation is the fictional amplification of a real concern. Let me take you through the full substance of what the real accountability picture actually looks like. We need to examine the documented historical pattern of Trump ally cooperation, what the turnover data tells you about the instability of the current administration, what the Inspector General referrals reveal about the accountability landscape around Trump officials, and what the combination of these three departures in the current legal environment actually means for Trump's exposure. There are several layers here, and each one matters for understanding the truth behind the headlines. Start with the turnover data from nonpartisan tracking organizations. The specific quantification of second-term cabinet-level departure rates provides the most authoritative available measurement of how unusual the current instability actually is. According to tracking data, the A-team turnover in the second term is running at roughly 1/3. That means approximately 1 out of every 3 of the most senior officials in the administration have departed. That is a historically extraordinary rate of turnover for any administration, especially one that is still in its early period. Now, high turnover in a presidential administration is not necessarily evidence of dysfunction. Some turnover reflects normal career transitions. Some reflects policy disagreements that are resolved through personnel changes. Some reflects the normal churn of complex organizational management. But 1/3 turnover of A-team officials in the early period of a second term before the administration has had the opportunity to accumulate the institutional knowledge and operational experience that makes governance more effective over time. That is a rate that reflects genuine instability rather than normal organizational evolution. This measurement is significant not just for the specific number, but for what it represents about the management environment that is producing these departures. A 1/3 A-team departure rate is an environment in which the loyalty over capability dynamic is producing personnel consequences. Officials are departing because the management environment requires a level of personal loyalty and a tolerance for specific kinds of conduct that some of them are unwilling to provide. That is not a fictional claim. That is documented in the circumstances of each departure. The Attorney General left because her handling of the Epstein files created accountability failures that became politically damaging. The Labor Secretary left while under an active Inspector General investigation. These are not people leaving for normal career progression reasons. These are people leaving because something went wrong. Now let me talk about the Inspector General referral history, because this is crucial for understanding the accountability landscape. The documented record shows that at least 5 former Trump cabinet officials from the first term were referred to federal prosecutors by inspectors general. Inspectors general are the independent oversight officials within executive branch departments who investigate waste, fraud, and abuse. When an inspector general finds evidence of conduct that may constitute a crime, they can refer the matter to federal prosecutors for potential criminal charges. The first-term record shows that at least 5 former cabinet officials were referred to federal prosecutors by inspectors general. That is a significant number. It reflects the extent to which Inspector General oversight identified potentially criminal conduct at the cabinet level during the first term. The fact that the Department of Justice declined those referrals does not eliminate their significance for understanding the accountability landscape. The referrals document that inspectors general found sufficient evidence of potentially criminal conduct to warrant referring the matter to prosecutors. The decision not to charge reflects prosecutorial discretion rather than a finding that the underlying conduct was innocent. And in the second-term context, The Labor Secretary's departure amid an active Inspector General investigation is specifically significant against this historical backdrop. An Inspector General investigation that was active at the time of a Cabinet Secretary's departure that was apparently ongoing when the Secretary decided to leave rather than continue in the role. That is the specific accountability situation that the first-term IG referral history makes most relevant and most consequential. Let me also talk about the Michael Cohen comparison more extensively, because Cohen's flip is the paradigm case for how the fictional cabinet flip narrative is constructed. Understanding what made Cohen flip, what the process looked like, and how it differed from what has been documented with the current cabinet departures is essential for evaluating the realistic prospects of cabinet-level cooperation. Cohen did not flip in a single dramatic moment. He went through a prolonged process, from loyal fixer publicly committed to protecting Trump, to subject of a federal investigation, to target of prosecution, to convicted criminal, to cooperating witness. The process took years. It involved his own legal exposure becoming sufficiently severe that cooperation with prosecutors was more attractive than continued loyalty. It involved a fundamental reassessment of his relationship with Trump following what he described as Trump's abandonment of him in the face of prosecution. And it produced cooperation that was documented, formal, and subject to the legal framework of cooperation agreements that define what the cooperating witness provides and what legal benefit they receive in exchange. None of the three current cabinet departures shows any documented evidence of a comparable process beginning. There are no reports of these former officials being subjects of federal investigation in their own right in ways that would create the kind of personal legal exposure that drove Cohen's eventual cooperation. The fictional flip narrative skips the entire process that made Cohen's cooperation possible and treats the departure itself as evidence of cooperation that the documentation does not support. That is not to say that none of these officials could ever cooperate with prosecutors in the future. The historical pattern shows that Trump allies sometimes do eventually cooperate, but the path from departure to cooperation is long, legally complex, and usually involves significant personal legal exposure. None of that has been documented in these cases yet. Let me also walk you through what would actually have to happen for any of these three departed officials to potentially cooperate with prosecutors in meaningful ways. Because understanding the realistic path to cooperation is essential for evaluating whether the fictional narrative is pointing at a realistic future possibility or a completely invented scenario. For cooperation to occur, there first has to be an investigation in which the cooperating witness's testimony would be valuable to prosecutors. That requires prosecutors to be actively investigating Trump's conduct in areas where the departed officials have direct knowledge. For cooperation to produce legal benefit for the cooperating official, there typically has to be some legal exposure on the official's part that cooperation would help resolve. The kind of personal jeopardy that makes the cost-benefit calculation of cooperation attractive. And for cooperation to be publicly known, there typically has to be either a formal cooperation agreement that becomes part of the court record or on-the-record reporting by credible journalists who have confirmed the cooperation through official sources. None of those conditions is currently documented in relation to these three departed officials. There are no reported federal investigations in which their testimony would be specifically valuable. There are no reported legal exposures that would create the personal jeopardy that drives cooperation. And there is no credible reporting of any cooperation agreement or formal cooperation relationship. The fictional narrative treats the departure as cooperation. It imagines that leaving the administration is itself evidence of flipping. But the historical pattern shows that the gap between leaving and cooperating is filled with a complex and usually prolonged process of personal legal exposure, prosecutorial interest, and negotiation that takes time and that produces documented evidence when it occurs. We are not seeing any of that yet. Now let me talk about what the prediction market interpretation of these cabinet departures reveals about how sophisticated political observers are evaluating the stability implications of these three exits. Research notes that prediction markets describe the resignations as having fueled speculation about Trump's stability in office. Prediction markets, where participants bet real money on political outcomes, are a specific and data-driven form of political assessment. They aggregate the views of many sophisticated observers who have financial incentives to be accurate rather than partisan. When prediction markets note that the cabinet departures are fueling speculation about stability, they are reflecting a market-wide assessment that the departures are politically significant in ways that go beyond their individual circumstances. That market assessment is consistent with the turnover data showing one-third A-team departures. It is consistent with the documented accountability failures on Epstein, on immigration enforcement, on Labor Department management that surrounded the specific departures. The prediction market stability speculation is the sophisticated observer's version of the fictional panic narrative. It acknowledges the genuine political significance of the departures without asserting the fictional cooperation claim that some viral content is building on top of the real instability signal. The market sees instability. It does not see flipping. That distinction matters. Let me address the specific accountability question that the Attorney General's departure creates in the Epstein file context, because this is where the real story gets lost in all the fictional drama. Her departure as Attorney General raises the most specific and most consequential ongoing question about what happens to the Epstein transparency that was not delivered during her tenure. We have covered extensively the document release failures. 3 million of 6 million required documents released. Heavily redacted. A Republican congressman catching a co-conspirator's name hidden in redactions until he confronted the Department of Justice, and it was unredacted within 40 minutes. That is not a fictional story. That actually happened. The discrepancy between what was promised and what was delivered. The tens of thousands versus over 10 discrepancy that raised serious questions about whether the department was complying with legal requirements. Now the Attorney General has departed. The remaining 3 million documents are still unreleased. The accountability for the redaction failures, for the discrepancy, for the accusations of misleading statements from members of both parties is still unresolved. The question of whether her replacement, whoever ends up managing the Department of Justice's Epstein file obligations in her absence, will deliver the transparency that the law requires, and that her tenure failed to produce, that is the most consequential ongoing accountability question that her departure has created. That is not a flip narrative. That is an accountability succession question. What happens to the transparency obligations that were not honored? The fictional cooperation drama obscures this real and unresolved accountability failure by focusing on invented cooperation rather than the actual unresolved issues that these departures leave behind. Let me also address what the most useful indicators of genuine legal danger for Trump actually are, and why tracking those indicators is more valuable for understanding Trump's actual legal exposure than following fictional flip narratives. The research itself identifies the most useful accountability tracking framework: formal indictments, subpoenas, on-the-record witness lists, not fictional or speculative cabinet flips built for drama. An indictment documents that prosecutors have found sufficient evidence of a crime to seek charges. That is real. That is verifiable. A subpoena to a specific former official documents that prosecutors want that official's testimony in connection with a specific investigation. That is a documented indicator of genuine legal pressure. An on-the-record witness list in a formal proceeding documents that specific individuals with specific knowledge are being asked to provide testimony under oath. Those are the documented indicators of genuine legal pressure, not viral videos labeled as fictional by their own creators. The fictional flip narrative produces dramatic content, I will give it that. It is exciting, it is attention-grabbing, but it does not produce reliable accountability information. And the American public's ability to understand what legal pressure Trump actually faces, to hold appropriate officials accountable for the conduct that generates that pressure is better served by tracking the documented indicators than by following fictional cooperation dramas that are explicitly labeled as invented by their own creators. When you see a video that claims multiple cabinet members have flipped to prosecutors, check the description. Very often it will say right there in plain language that the story is fictional. That should tell you something important about how to evaluate that content. Now let me bring this all the way home with the 3 things that matter most about these cabinet resignations and what they actually mean for Trump's political and legal situation. I want every one of these to land with complete clarity. The first is about what the documented circumstances of these 3 departures actually reveal about the management environment producing the instability. The Attorney General's Epstein accountability failure. The Homeland Security Secretary's contested exit framed as a reassignment. The Labor Secretary's Inspector General investigation. These 3 patterns together describe a management environment where accountability failures, political costs, and personal legal exposure are driving cabinet-level turnover in ways that are genuinely significant for the administration's institutional capacity. But they are very different from the fictional flip narrative that has been circulating online. The specific circumstances of each departure tell a coherent story about how the management environment is producing cabinet-level exits. Officials who generate accountability failures that become publicly damaging are removed or pressured out, because their continued presence creates political costs that outweigh whatever institutional continuity their retention would provide. Officials whose departures serve the administration's framing needs are managed through spin rather than through transparency about why they are actually leaving. And officials whose own conduct becomes the subject of oversight investigation face the specific choice of staying under investigation or leaving. In the Labor Secretary's case, that choice apparently resolved in favor of leaving. Those 3 patterns are genuinely significant for the administration's ability to govern, but they are not evidence of flipping to prosecutors. The second point is about what the historical first-term record of eventual Trump ally cooperation means for how to think about the realistic future prospects of cooperation from departed second-term officials, without treating the fictional narrative as already documenting that cooperation. Cohen's flip, Gates's cooperation, Flynn's initial cooperation. These are real and documented instances of Trump allies eventually cooperating with investigators. They establish that the pattern of eventual cooperation is real and historically grounded. But they also establish that cooperation is a process, a prolonged, legally complex process involving personal legal exposure, prosecutorial interest, and formal agreement, not an event that happens automatically when an official departs. The realistic assessment of whether any of these 3 departed cabinet officials might eventually cooperate with investigators requires watching for the documented indicators of that process beginning. Reports of personal legal exposure, reports of prosecutorial interest in their testimony, reports of formal cooperation discussions. None of those are present yet. The fictional narrative collapses the entire process into the departure itself. Accurate accountability tracking requires maintaining the distinction between someone leaving a job and someone formally agreeing to cooperate with prosecutors against their former boss. That distinction is not just academic. It matters for understanding what is actually happening versus what someone wants you to believe is happening. The third point is about what the most useful indicators of genuine legal danger for Trump are, and I have already touched on this, but it bears repeating. Formal indictments, subpoenas, on-the-record witness lists. Those are the things to watch, not fictional cabinet flips built for drama. An indictment documents that prosecutors have found sufficient evidence. A subpoena to a specific former official documents that prosecutors want that official's testimony. An on-the-record witness list in a formal proceeding documents that specific individuals with specific knowledge are being asked to provide testimony under oath. Those are the documented indicators of genuine legal pressure. When you see those things, you will know that the legal accountability process is moving forward in a real and verifiable way. Until you see those things, treat dramatic claims of mass flipping with a healthy dose of skepticism. So where does all of this leave us right now? 3 cabinet members have departed in a compressed period: the Attorney General, the Homeland Security Secretary, and the Labor Secretary. Their departures happened in circumstances involving Epstein accountability failures, a contested exit framed as reassignment, and an active Inspector General investigation. Nonpartisan tracking puts the second-term A-team turnover at roughly 1/3. At least 5 first-term cabinet officials were referred to federal prosecutors by inspectors general, though the Department of Justice declined those referrals. A viral YouTube video explicitly labeled as fictional narrativizes multiple cabinet members flipping to prosecutors. Another fictional video imagines 9 cabinet flip scenarios under immunity deals. The historical record of first-term Trump ally cooperation, Cohen, Gates, Flynn, establishes that eventual cooperation by Trump allies is a real and documented pattern, but also a prolonged process rather than an automatic event. None of the 3 current departed officials has been verified as cooperating with prosecutors in connection with Trump's conduct. The genuine instability signal, 1/3 A-team turnover, 3 cabinet-level exits in a compressed period, accountability failures driving specific departures, that signal is significant and real. The fictional flip narrative is an invented amplification of that real instability. It obscures the real accountability story by substituting dramatic invented cooperation for the specifically documented circumstances of departure that are consequential enough on their own terms. The American people deserve better than fictional drama dressed up as news. They deserve accurate information about what is actually happening in their government. And that accurate information is clear. 3 senior officials left. Their departures reveal real instability and real accountability failures. But there is no verified evidence that any of them have flipped to prosecutors. Not yet. Maybe someday, but not today. And confusing what might happen someday with what has already happened today is how misinformation spreads. The accountability questions left behind by these departures are serious enough without adding fictional layers. What happens to the Epstein transparency obligations that were not fulfilled? What will the Inspector General investigation of the Labor Secretary eventually produce? How will the administration fill these vacancies, and with whom? Those are real questions with real consequences. They deserve our attention. The fictional cooperation drama is a distraction from those questions. A compelling distraction, sure, but a distraction nonetheless. And in a time when accurate information matters more than ever, we cannot afford to be distracted. We need to keep our eyes on the documented evidence, the verifiable facts, and the real accountability processes that are actually unfolding. Not the dramatic inventions designed to generate views and shares. The pattern of Trump allies eventually cooperating with investigators is real. It happened in the first term. It could happen again in the second term. But when it happens, there will be evidence. There will be court filings. There will be news reports from credible journalists who have confirmed the information through official sources. There will be something more than a video description that says, "This story is fictional." That is the standard we should hold for accountability information. That is the standard this channel has always tried to meet. And that is the standard we will continue to hold as we track these stories and bring you the most accurate information available about what is actually happening in the Trump legal accountability proceedings. Stay tuned, because the next video is going to cover what specific accountability mechanisms exist for pursuing the outstanding questions created by these 3 departures. What happens to the Epstein file obligations that the Attorney General's tenure failed to fulfill? What the Labor Secretary's Inspector General investigation may eventually produce in terms of formal accountability findings, and what the turnover data tells us about the administration's capacity to govern through the challenges ahead. Trust me, you are not going to want to miss that.